Welcome to the CRA Confidential Bulletin Podcast. I'm Jot Condi. The abuses of California's Private Attorney General Act, known as PAGA, have been a disaster for employers. Since PAGA's 2004 enactment, there have been countless attempts to fix the law, but trial lawyers and unions use their powerful grip on the legislature to either kill those efforts or water them down to near meaninglessness. So the PAGA reform, signed into law this week, marks an important milestone in the 20-year history of this job-killing law. These historic reforms are the result of a 3-year effort by the California Chamber of Commerce, led by Jennifer Barrera, the California New Car Dealers Association, led by Brian Moss, and the Western Growers Association, led by Dave Puglia, and of course, CRA and its board of directors who made PAGA a top priority. Together, our 4 organizations raised over $10 million, collected nearly 1 million signatures, and placed the PAGA reform measure on the ballot. It was that ballot measure, coupled with aggressive public affairs and lobbying efforts, that created the environment that drove the governor, labor, and legislative leaders to the negotiating table. Today, Alden Parker, partner with Phillips law firm and a CRA Legal Center partner, interviews 2 of his fellow Phillips partners, Ben Ebbink and Lonnie Giamela, who served as counsel to CRA in the negotiations that resulted in this historic reform. They, along with Cone Restaurant Group CEO Michael Feynman, also a lawyer, were key players in the ultimate outcome of the long and intense negotiations. So please take a listen as Alden, Ben, and Lonnie discuss the recent changes to the PAGA law and the practical impacts for employers and workers alike.
And now for a word from our sponsor.
I've noticed the flowers are blooming and the bees are buzzing. That's great, but it also means allergy season is upon us. Not feeling like driving to the pharmacy to pick up those meds? Don't bother. Get your meds delivered. DoorDash, your door to more. Download the DoorDash app now to get almost anything delivered. Must be 21 and older to order alcohol. Drink responsibly. Alcohol available only in select markets.
All right, thank you, Jot, for that warm introduction. I really appreciate you, Ben, and you, Lonnie, joining us today. This is such a great, important change for a lot of the restaurant industry. I represent a lot of restaurants, a lot of employers that have either single-site or multi-unit operators, and we've been having just a huge struggle with PAGA for years. So anytime that I caught a whisper of a reform package or an initiative, I really wanted to dive in and find out as much as I could from my colleagues. And Ben and Lonnie, you guys have been instrumental in this. It's just an amazing Herculean effort that you guys have brought to the table for this. I'd like to start with Ben. Ben, could you take us through sort of how this came to be or how the reform ended up being on the table or a possibility here?
Yeah, it's a long story. It's 20 years in the making. Just a month or 2 ago, I did this podcast for Jot, a 2-part podcast, and we talked about sort of the history of PAGA, how it was enacted, the unique political dynamics that were going on at that time. Gray Davis was being recalled and was angry at the business community. Spent a lot of time talking about kind of how we got here and how challenging PAGA has been for the last 20 years and why there's been little, if any, reform in the legislature over those 20 years. We got a very, very modest reforms under the Brown administration, and it was like pulling teeth to get the legislature to do anything. So sort of with that backdrop, a couple of years ago, the business community, including CRA and other groups, decided, well, the legislature is not going to do anything. So we have no choice but to go to the voters. And so they qualified the measure for the November ballot, which essentially would have repealed PAGA in its entirety and replaced it with, I would say, some more vigorous agency enforcement. So that was really the direction we were heading. The measure did qualify for the ballot in November. As routinely happens when you have ballot measures, it does create a dynamic where the legislature has an opportunity, the legislature and the governor have an opportunity to say, well, maybe we can come to some compromise in lieu of the ballot measure going forward. And that occurred in this case. There's a June 27th deadline to remove ballots that have qualified from the November ballot. And so a few months back, there began to be some outreach and some discussions between labor, the business community, and the governor's office about whether there would be, an opportunity to do some legislative compromise in lieu of the ballot measure. Now, why would the business community consider legislative compromises as opposed to going forward with the ballot measure? Well, like with any ballot measure, there's no guarantees, right? Politics is an interesting place in California. It's an expensive place in California. So there were some uphill challenges with the ballot measure. I think number one, just the cost. The business community, CRA, and other groups had raised somewhere between $10 and $20 million for the campaign for the ballot measure in November. But the reality is, in California, campaigns cost $150 to $200 million. The other issue, unfortunately, ballot initiatives and that whole process is a political process in California. And we have the Attorney General who writes the ballot title and summary. And this is when the voter, Joe Q. Public, goes into the ballot booth and reads the voter guide and the ballot, this is what it says. And we got a very, I would say, poorly worded ballot and title summary for the PAGA initiative. It said something like, eliminates the ability of workers to sue for civil penalties for labor law violations. And that's all it said. And I think, your average member of the public who's probably not a business owner, who hasn't been subject to PAGA litigation, would read that and would probably say, well, that sounds terrible. That sounds like it's bad for workers. So those were sort of some of the uphill battles I think the initiative faced, which is why, the business community and CRA and other groups did come to the table and try to, see if there was a compromise that could be reached in lieu of that uncertainty of going forward with the ballot measure.
Well, and I know CRA really had some real goals as part of this that we were looking to achieve and get out of this in an effort to trade the initiative for meaningful reform. But Lonnie, I know you're a fire breather, litigator. You've been dealing with this for years, and there are a lot of restaurants that have been touched by PAGA over the years, quite significantly. I also know it's personal to you. You come from a restaurant family. What's the litigation landscape been like?
Yeah, I think there was a litigation track to this political track that I think necessitated this positive compromise for restaurants across California and a win in many respects. And I think over the past 3 to 4 years, as we've tracked the Viking River case and the Uber versus Adolf case, there was some belief that the courts would reform PAGA and allow us to utilize pre-dispute arbitration agreements to at least strike representative claims, possibly. And I think that ship, no pun intended, sailed after Viking River in it. And that's when I think those in the business community, along with their counsel, started looking at the ballot initiative as really one of two ways, other than legislative fixes to PAGA, to do it. And the most important thing, and I come from a small business family that owns Italian restaurants in the San Fernando Valley, is how onerous these penalties are, and really how there was no method to get out of this case prior to trial, absent some litigation strategies that may be developed by counsel. There's no manageability like there is in class action cases per recent decisions. And I think CRA and the business community, as they approach these negotiations, really took into account both not just how the litigation can be reformed, PAGA litigation, but also how preventative advice and everyday activities by a restaurant could dissuade somebody from even bringing a claim in the first place, understanding that reasonable steps, and we'll get into it in a little bit, how these preventative measures could not only reduce risk, reduce liability, but also improve morale and compliance to the point where you could be able to clearly demonstrate your attempts to properly comply with the law here in California.
Yeah. I mean, I think the litigation landscape, too, from my perspective, has just been a hellscape over the last few years. I mean, with the restaurant community experiencing, increases in labor cost, increases in food costs, and then to get hit with what I saw as inflation in the demands from the plaintiff's bar in this area, where all of a sudden every case, was was supposedly worth $1 million, no matter how many pay periods you had. This was hugely impactful. I mean, it's one of the contributing factors to why, U-Hauls cost so much leaving the state and they're so cheap coming into the state, because laws like this make for a very unfriendly environment. Let's get to some of the reform package, because it's interesting to think about this concept of pre-announcement PAGA cases and post-announcement PAGA cases, and what the reforms may actually mean very practically to the restaurant industry. I understand there's some sort of reduction in the possible penalties at stake. Lonnie, could you sort of shed your perspective, or share your perspective on what those possible penalties are coming out of this reform?
Yeah, absolutely. So we start with the premise of what it was before. That's the easiest way to think about it, which was it was $100 up to $100 per pay period per violation. And then for a quote subsequent violation, it would be $200 per pay period per violation. And there was no real legislative guidance as to bringing that number down automatically, except to state that the court had the discretion to bring those numbers down. And what we found is not only did that cause a problem, but what was a subsequent violation. And I think one of the goals of the CRA in the business community was not only to provide clarity, but to provide tangible examples within the statute on how an employer, either prior to receiving notice or within the 60 days after receiving a notice that's been sent to the Labor Workforce Development Agency, could automatically reduce penalties. Go to a plaintiff's attorney, a plaintiff, a mediator, a judge, an arbitrator, and say, hey, look at this, look what we've been doing. And so what the statute provides, the term of art is known as reasonable steps. And there was, out of all the language that was negotiated, and Ben and I were part of this, and we can discuss it, this was probably one of the 2 or 3 most debated topics, without getting into too many specifics about it. And what we found is we defined that there is a pre-notice. Essentially, once you become aware of a potential lawsuit, PAGA lawsuit, there's a dip down to 15% of penalties if you engage in reasonable steps. And there are 3 main reasonable steps are wage hour audits, to which a response is made to it, training, where you, in essence, you train supervisors and employees on your wage and hour practices, and handbook updates. Now, again, these are not the only 3. It is a totality of circumstances test, meaning based on resources, violations, what you find, how compliant you are, what you do, any number of things. These are 3 of the ways that you can automatically go and be able to reduce your penalties. Now, if you find out about it after receiving notice, that 15% is actually 30%. It'll drop down to that amount and reduce the penalties from 0 to 30% of what would otherwise be issued. And again, you have 60 days to engage in those same reasonable steps. And what this means for a restaurant is, and my dad uses this analogy, he talks about it to me all the time as it reminds me of it. Some 2 or 3 years ago, he had a problem. We slice all our meats in-house, and the meat slicer was 30 years old. He kept replacing this ticky-tack blade, whatever it was. And he finally sat down and invested in a new model, updated Globe or similar type of automatic meat slicer. And he said that investment is going to save me cost. It's going to increase productivity. It's going to decrease liability and risk because there's an automatic feature to it. And I may avoid a work comp claim, things of that nature. And that's what these reasonable steps are. You're making an investment by engaging in these things, these reasonable steps, through various measures, whether it be, looking at your HRIS system or your POS system and how you keep time in there and making sure that's proper, and auditing just processes, updating your handbook annually and ensuring that that's the case. including with respect to when you're training employees and managers on harassment prevention and workplace violence and other obligations. It's including now wage hour training, or uploading that as a 15 or a 20-minute training session that's comprehensive enough that is part of a new hire orientation package that people review to make sure that they're aware of that. But these reasonable steps are going to be a key factor in reducing potential penalties, but more importantly, reducing potential settlements, understanding with the thousands of these claims that are filed each year, some percentage in the high 90 percentile settle at some period of time. So that's going to provide some relief, particularly to restaurants that may be small businesses or medium-sized businesses particularly.
This is really what resonated in getting to a deal with the labor community and the governor's office, is that they want employers to follow the law. And so when you go back to the original PAGA, they claimed that was the intent. Like, we want a heavy hammer so that there's an incentive out there for employers to follow the law, not violate the law. So I think that's where we were able to get to a deal. Like, we want this restructured penalty provision to incentivize employers to do preventative measures, reasonable preventative steps up front. And then if something is brought to their attention, take reasonable prompt steps to address that concern going forward. And that, resonated at a policy level, I think, with the governor, and labor couldn't really object to that. So I think that's really, important in what drove getting to the revisions we're talking about right now.
I mean, I think this is real meaningful change, right? Because it gives the restaurant owner a chance to do something proactive. Lonnie, your example of sort of the penny wise, pound foolish decisions that may go into holding off on, older equipment or dangerous equipment, and then investing in a new piece of equipment for the kitchen that really goes ahead and sets the stage for future success. Here, the employer can get a request for records from a lawyer's office or an LWDA PAGA notice and do something about it. Look at changing policies that may have outdated language. Look at auditing their manager edits to see if there's an unusual high amount of manager edits, or look at attestations or auto pay of, potential meal period violations, and not even disputing those, just paying the premium hour. But it gives us a fighting chance, I think, in the litigation, Lonnie, don't you?
Yeah, absolutely. And I think going back to where I started from about the 100-200 dichotomy, we approach it, as Ben said and eloquently did, about how the goal is to prevent wage theft. What the goal here was to say, look, we're going to use $100 per pay period, which has been the standard for the 20 years PAGA has been in effect, and find multiple ways where, based on preventative or proactive conduct by an employer, it's automatically going to go down. Now, in exchange for that, as Ben said, if you have gross wage theft or individuals who have been at least once notified in 5 years about an issuance of a determination that a policy or practice is unlawful by a court or labor board, that's where the heightened penalties come into play. So it's no more initial subsequent, it's more sort of everybody default, and then this minutia of repeat offenders or conduct that is so gross, sort of like punitive damages, like it's so malicious, the conduct, that the court can consider it. But there are, when you take a look into the nuances of the statute, multiple ways now in which default penalties are statutorily reduced, meaning you start as a default lower, that'll assist us in this case. Now, again, this is, part of it is requiring restaurants to engage in these for their benefit. They're going to be saving significant amounts of money, depending on their size, in a PAGA settlement or in a lawsuit if there are damages awarded, by engaging in these preventative advice, reasonable step type activities. And it can be any number of things. Some of them are not super complicated, by, let's say, updating a handbook or training and uploading a training program and producing content, perhaps with a vendor or with the assistance of counsel or a consultant or in-house, for example. But we see now, and I know, Alden, you and I have talked about this, and I'd welcome your thoughts on it. I mean, The deadline where all of this now comes into effect is for any LWDA letter or lawsuit filed after June 19th. Okay, June 19th was sort of our pivot date. And it's ironic that in the week before that date, essentially June 12th, 13th, this to June 19th, we saw a skyrocket in the number of LWDA letters. And that should be indicative, or at least symbolic, of the concern that plaintiffs' bar have over how impactful these reform measures are that the CRA and the business community achieved as part of this deal. There were things that labor wanted, there were things that the business community wanted, but on a day-to-day practical basis, both from, and particularly as a litigator who does countless of these, and you do too, it's going to assist us in so many different ways, getting better deals for restaurants and for employers in these PAGA cases.
Well, and we're going to have to immediately know what's in this and how to execute on it in litigation, because we saw that increase you're talking about, Lonnie. Typically, we see maybe 110 to 160 PAGA notices get filed a week, which is an extraordinary amount on its own. To think that many are getting filed week after week after week. But last week, I mean, there were over 650 PAGA notices filed in 1 week. That's an avalanche.
Yeah, it's going to be more than 10% probably of the total number of PAGA letters in the year. Almost, if you just take it statistically, were filed in 1 week, and that should be indicative of it.
It's amazing. Ben, I saw that there was another reduction. There was another reduction to $50 per aggrieved employee if it was an isolated or non-reoccurring event that didn't last very long. How did that come about, and maybe what were the politics or the impetus behind those sort of that further gotcha type reduction?
That reduction was aimed at, sort of your inadvertent error, might be an error with your payroll system or something that, certainly is not intentional or any fault of the employer, but just something that is isolated, sort of a one-time thing that comes up. And so there was acknowledgement from the other side that, we can have a reduction of that place as long as, there's some parameters around it. It doesn't extend beyond, a certain amount of time. We can limit those isolated one-time sort of inadvertent errors to a lower penalty amount. There's also reductions here for the cure. There's some revisions to the right to cure provisions depending on size of employer. There's actually an expanded ability to cure violations for more provisions of the labor code than you could under PAGA previously, and those allow for reduction or elimination completely of penalties if you actually cure the violation. So there's multiple sort of reduction of penalty provisions part of this reform. I did just want to mention the June 19th reference brings to my, we've been getting a lot of questions about the retroactivity question about is this going to impact pending PAGA cases, or is this only PAGA cases going forward? And as much as we all would have loved this reform to impact those pending PAGA cases we have, I think that was just unlikely to occur. The legislature traditionally has been very abhorrent of anything that impacts pending litigation. And I saw it time and time again when I was working in the legislature. They were very reluctant to touch or impact any pending litigation. And so they routinely would say, bills of this magnitude that change the landscape only apply on a going forward basis. And so that was part of the insistence of the other side on this, was language in this deal that says it's, the June 19th deadline. And we saw that, reaction. Somehow the plaintiff attorneys found out about that date, and they knew they wanted to get all their PAGA notices in before that deadline hit so that it would be covered under the, existing PAGA law, but everything going forward. So as much as it would have been nice to apply this to all those big PAGA cases restaurants have going right now, I think that was unlikely from the get-go. The legislature just, never really been a big fan of doing that. And at the end of the day, the other side was very insistent of driving home that point. So unfortunately, this does, only apply on that going forward basis.
It's pretty frightening that they have so many people waiting in the wings that they can just all of a sudden flood with PAGA notices in 1 week. Those people didn't all contact them that week. They were waiting in the wings and metering these folks out almost like a manufacturing line. And then all of a sudden, boom, they go ahead and flood it. I like the isolated instance where you go ahead and get a further reduction in the amount, especially for the restaurant community, because invariably we open up a new location and it's sort of chaos. We overstaff. We may have switched payrolls for that entity. We may take over a different brand or open up under a new franchise opportunity that a portfolio restaurant company may have. And all of a sudden, we have a new system. We might get a name wrong. We might get a new payroll system where it just has some period of time where some things need to get worked out. And being able to maybe have the flexibility to get a further reduction when those arise, so it's not some gotcha litigation, I think is really valuable. And it fits into, Ben, what you're saying about trying to balance, labor's need for making sure employees get paid properly with the business community and making sure that it's just not some sort of sledgehammer against them.
And I think the other area this could come up, particularly for restaurants, are those isolated, meal and rest violations that aren't part of the practice or the policy of the restaurant, but occasionally things are, crazy in a restaurant, crazy busy, and somebody might miss a rest period or get a slightly late meal period. And as it gives us the ability to argue that if those are truly isolated, sort of one-time events, aren't routinely happening to the employees, and certainly not because of the restaurant's policy or practice, that those type of penalties should be reduced to that $50 amount as well.
Yeah, sort of like Mother's Day every year. Mother's Day every year.
In that though, Ben, which I think is one of the subtle sort of things that aren't as provocative or haven't hit the headlines as much as the reduction in penalties that we talked about earlier, is that the CRA and the business community approached the reduction of penalties available in these cases not just from a percentage reduction, but from what's referred to as a standing issue as well too. And so for those that aren't aware, there was at least a line of case law that said if you had a cashier that missed a meal period and then had a delivery driver that wasn't reimbursed for mileage for making a delivery in their car, hypothetically speaking, the cashier could represent him or herself in the meal period claim and also have the standing to go after the reimbursement claim, meaning that they don't have to be aggrieved for each of the violations. The statute changes that. The statute says that an aggrieved employee plaintiff can only recover penalties for the violations himself, herself, or themselves occurred or incurred themselves. And not only that, it went one step further. Elsewhere in the statute are amendments to discuss a prohibition about double dipping on penalties for derivative claims, such that if I had a meal and there was some other penalty associated with it, you couldn't just say multiple penalties are available in it. And it's called the derivative violation provision that's in the amendment. So there are multiple ways that, and I think CRA and the business community did a great job of looking at this, both from a practical standpoint of how restaurants operate on a day-to-day basis and what they can do to stop, from a settlement perspective and how we can draw down settlements, but also to the extent it goes further in litigation, and it also may impact settlement as well too, how we're reducing penalties that are just onerous or oppressive and unnecessary. Because again, as a reminder, all of these penalties aren't wage related, meaning you're not reimbursing someone for the wage. Now, part of the cure provisions, because we talk about lawyers, may require you to cure by, retroactively providing wages and truing people up in certain circumstances. But from a day-to-day basis, we looked at it from how do we reduce the penalty amount by percentage wise? How do we also provide for various cure provisions? How do we stop derivative claims? And then how do we do it in multiple different fashions by responding to some of the more court cases and policy arguments that may have been adverse to the business community over the past several years?
Yeah, I think CRA did a very good job in these discussions about having, two big overarching goals, right? One is addressing sort of the scope of the litigation that we're seeing in PAGA and sort of bringing some common sense reform to rein in the scope of these claims, because it had sort of been the wild, wild west. There were no class action standards. The courts were all over the place in terms of the issues Lonnie was talking about. And those were, I think, just, really successfully addressed in this reform package. The limits on standing that Lonnie mentioned, the derivative claims, because every claim for a meal period has a wage statement claim and a waiting time penalty claim, and they piled up on top of each other. So there's language to address those issues. There's some language aimed at manageability, which gives the court's ability to limit claims based on whether they can be effectively tried. So I think that all goes to limiting that scope of the litigation issue. And then the other big bucket was, let's bring some common sense to reduce these penalties, to incentivize employers to do the right thing and bring these penalties down and reduce the situations where you're having these astronomical penalties for a technical violation where there was no harm and no intent by the employer. I think looking at through those two lenses, I think CRA did a very good job of getting meaningful reform that addresses both of those large buckets.
I love the standing part because, I think back to several cases I've had where, and I'm under no illusion, I don't think the complaints are going to change that get filed. They're going to have everything in them. They're going to have rest, meal, off the clock, cell phone reimbursement, 226 claims, waiting time. They're going to have everything. But I just flash back to all these depositions I've taken where I actually get in the room and I take the deposition of the plaintiff, and they never experienced a rest period claim, and they admit it under oath, or they've never used their cell phone for business purposes. And I'm thinking to myself, those are just going to fall off the board then once we get to a negotiating table, and that's going to provide a meaningful benefit. But guys, I'm interested to hear about your guys' thoughts on the cure provisions for large and small employers. Can you guys give a little background on those discussions and how we ended up with that and what it really means?
Yeah, so I'll talk about it from sort of a high level, and then Ben can get into the weeds. So there are multiple ways in which an employer can cure. For a smaller business, it predominantly involves, once you get a letter from the Labor Workforce Development Agency discussing the right to cure and the desire to do so. Now, previously, there was no real process determined on how you exactly do that, who validates it, and what happens. And now, in the new statute, it's probably one of the more substantive, meaning from a lengthwise. If you're looking at where is it the longest amount quantitative word-wise revised, it's probably in these two sections. And so long story short, the cure you have for a smaller business has the ability to go through an LWDA process through the Labor Workforce Development Agency. And there's an ability to signal you want to cure. There's an ability for the employee's representative to challenge that, and a process then for adjudication. Similarly, there is a basis in civil court as well for processes about curing and a discussion about that and what you intend to do. To me, the positive about it is that it provides an opportunity, at least, to control what happens. One of the things to consider, though, is that in the cure provision, at least for certain parts of it, and depending on what type of violation it is, it may require a retroactive wage payment of up to 3 years for all of the impacted employees. So if you have a rest period claim, for example, that's going to be very, very difficult to consider whether to cure, because it would almost require full rest period reimbursement for 3 years for everybody, because then the question is, did you cure fully? And that's going to be a push-pull with the meal and rest period claim. It's a great tool, though, because whether it be through these cure provisions or an early neutral evaluation, when you're sued, to go to a court and say, hey, I want to sit down and try to resolve this type process and fix this. It's a great tool for employers to have, particularly in more serious and widespread issues, or also just for ticky-tack. If you have 2 violations and you know it, you can just say, I know what it is, I'll just go pay these people and move on with the process.
Yeah, I really think it's It's a more meaningful. I mean, we had right to cure under PAGA, but it was almost meaningless, right? I mean, it was so limited in terms of the types of claims, types of labor code violations you could cure, and there was no real process. So this, I think, really puts some meat on the bones. And again, as Lonnie said, folks will have to evaluate whether right to cure makes sense in their given situation based on the type of violations you're facing. But it does, a couple of main things. Number one, it opens the door to a lot of curing a lot of violations that you couldn't cure previously. Overtime claims and expense reimbursement and other claims are now, potential to cure those type of claims before a violation can go forward. The smaller employers, less than 100, you have the labor agency process where you basically take a confidential proposal to them and say, we've received the PAGA notice, and this, we've identified some issues. This is our proposal to cure those violations. And then there's you know, subsequent agency process to evaluate and approve that right to cure. And so I think that's going to be very effective. I think that provision, if I'm not mistaken, Lonnie, that provision doesn't kick in until October. I think there was a little bit of a ramp up period for the labor agency. There's some budget funding that goes along with this for them to be able to have enough staff to be able to handle those issues. And then the larger employers have the early evaluation process. So I feel like for the first time, we're actually having a meaningful right to cure process under PAGA, because previously it wasn't really meaningful or practical for anybody to use it.
It'll put a real premium on people analyzing the issues right up front. And I don't know if I would be too reticent to introduce the subject of a large payment through this process of back pay to employees, because you're going to have to agree at the negotiating table. Practically most of these cases resolve at mediation, and you're going to be putting money up through that process. I think it would be better and probably less expensive taking out how we negotiate these gross settlement amounts in mediation. Probably less expensive to go through this process, but the numbers will bear that out. Guys, I can't remember, and I'd love your thoughts on this. If someone is a small employer and they go through the LWDA within 33 days with an offer to cure, does that divest the plaintiff's attorney of the ability to go to court after day 60? Is it frozen until the LWDA acts?
Sort of, I guess. It would be with an asterisk. So what it does, it essentially tolls the deadline, the stay period, while the matter is being considered. And then if no action is taken by the LWDA in that period of time, 120 days, Ben, I think it is, then the plaintiff's bar can go ahead. So it deals with a situation where if there is an action or no action taken, it's done. So that cure period remains in place, such that an employer can say you haven't exhausted your administrative remedy because the deadline hasn't come into place. I think the struggle that we're going to see, and this is, I think, the main takeaway for restaurants, if you're, in addition to the preventative advice, reasonable steps stuff we talked about earlier, is the importance of, once you get that letter in the mail requesting a personnel file, that's not what starts these periods. It's the LWDA letter. And there's going to be a window of opportunity there. And the response that we do and how serious we treat any correspondence from an employee's attorney is paramount now. Because whether you cure, how you cure, whether you're starting to do the audit within the window, doing reasonable steps immediately before you get the LWDA letter because you have an attorney who hasn't yet filed an LWDA letter, but just has a records request to you. Although there is some issue in the statute about that, about when the cure provision takes place in it, because a records request could qualify depending on how it's phrased. It might just be a demand letter, for example, and you have to look into that. But every correspondence now is key in doing that. And I think at the end of the day, there is some deadline to consider it. But again, someone shouldn't be reticent to say I have 60 days or 120 days. Once I just send in a letter and I'll do it myself as a restaurant owner, there's a lot of work that's going to go on to assist collecting records, analyzing records, getting advice, developing strategy, and budgeting. Because I see, and Ben, I think you'd echo this, is that the funding for this cure process doesn't kick in till October, which means you're going to have in the next 2 or 3 months a gluttony of potential cure provisions later on this year, where the LWDA is bombarded and courts are bombarded with court provisions, and they need to navigate through that as well too. And to be prepared strategically for that navigation is going to be instrumental to a restaurant's defense in these types of PAGA cases going forward.
Ben and Lonnie, as we think about this reform package, there's lots that are going to take a while through litigation to sort of end up being decided. But what impact do both of you see in terms of litigation over the next 6, 12, 18 months?
I'll let Lonnie go into details as he's the most experienced litigator, more litigation than I. I think overall it gives us from my perspective, a better starting position in these discussions and negotiations. And yes, there are some terms here and some things that will require some court interpretation, and we'll have to see how that plays out. But I think it gives us a much better starting position to go into settlement negotiations, saying I've done X, Y, and Z. So our starting point for discussion, which used to be here, is now here, and we go down from there. And so I think hopefully that's going to drive, everything to lower settlement discussions. But it's true. I mean, there are some, terms here, some issues here that will need to be litigated, and there's going to be disputes between the two sides. But overall, I think it gives us a much better starting position from negotiations, and so I think that's a tremendous benefit to this reform.
Agree with Ben. This is gonna provide a series of arguments and new positions that we can take and sort of respond to some of the court cases in the past. A couple of things, particularly for larger restaurant groups. I sense many times that those who get these frequently draw out the process in order to say more pay periods, larger groups equal a reduced settlement, and we're going to get this 2 years from now again. We always just seem to be getting it no matter what we do. I think that strategy is going to go away now, particularly with the current landscape of existing cases because of the reduced penalties that are now in the future. And I think as well, too, there's going to be an importance, at least for these audits to really be able to look at and tweak processes, to be working with payroll providers and counsel who are familiar with working with restaurants on what practically can be done, because there are practical considerations in it as well too. And I think finally, at the end of the day, there's at least more clarity on a series of topics: standing, manageability, the amount of penalties, when subsequent violations. And all of those negotiated by the CRA and the business community tip in favor of the employers now, more so than it did before, meaning that the new rules are more favorable on all of these key parts, which I think at the end of the day is a good win for the business community.
Those are great thoughts. I mean, I definitely like that it rewards people being proactive rather than waiting. And for existing litigation, I mean, you're going to want to resolve those cases and cap all of the pre-June 19th litigation to move past that, and then free yourself to start looking at it under this reform that both of you were able to land for the community. I mean, it's just, I think it's a big win. There are parts of it that will take a little while. It's not a light switch that we're just turning on the lights. It is going to have an impact. It's just going to take a while to see what that impact is. And in the meantime, when you get those letters from the LWDA, when you get the records requests, we got some opportunities there to do something rather than just wait and eventually have a mediation where someone asks you to pay a bunch of money. Well, thank you guys. I appreciate all of your thoughts, all the work on this that you did in conjunction with CRA and the other coalition groups. It's just amazing for the community to see something meaningful happen rather than just a little nibble around the edges. This is impactful, and it's going to make a difference.
Yeah, looking forward to it, and great hard work done by CRA and many others, and glad to be a part of it.
And Ben, as always, thank you for all of your contributions to CRA and the work that you're doing there. And Jot, amazing job. CRA has been a longtime supporter. We've been a long-time supporter of them, and always appreciate the opportunity to talk with their members.
We hope you enjoyed Confidential Bulletin. Your membership helps us advocate statewide on your behalf. You can also access tools and education that can help you be a better and more profitable operator while connecting with more than 22,000 like-minded hospitality professionals just like you. If you are not a member, join us. Check us out at calrest.org. This podcast is for informational purposes only and should not be considered legal or professional advice. The views expressed in this podcast may not be those of the host or the management.